Doctor, do you consider this textbook to be authoritative? No, I don't. Doctor, do you consider this textbook to be authoritative? No, I don't. Doctor, do you consider this journal to be authoritative? No, I don't. Doctor, I'm going to read two statements from one of these textbooks and ask you whether you agree or disagree with this statement. Objection! The defense attorney yells out. What's the objection? You know that unless the doctor says that this textbook is authoritative, you know you can't ask that question. What are the other two types of questions that I can't ask that are going to get an immediate objection that tells the doctor, do not answer this question? Anybody know? This is interactive. Okay? There are two types. Come join me on this journey this morning as I share with you that information, as well as other information you are going to know and going to need to know during the course of your legal careers. Hi everybody, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer to the question is questions that are privileged and questions that are palpably improper. So this occurs during the course of a deposition. What type of question would be palpably improper? Doctor, how many times do you beat your wife each night? What? That's a ridiculous question, right? It's got nothing to do with the claims in the case. It has nothing to do with the defenses in the case. So in that instance, the defense attorney would be well within his right to turn to his client and say, Doctor, I direct you not to answer that question. The other instance where the defense attorney would be well within his right to tell his client not to answer the question during a deposition in a medical malpractice case is, Doctor, before coming into court, before coming into this room to testify this morning, did you have a conversation with your attorney? Objection, that's privileged. Actually it's not. The fact that the doctor had a conversation with the attorney is not privileged. What's contained within that conversation is, actually that's the follow-up question. Doctor, what did you and your attorney talk about? Objection. Do not answer that question. So why do I share that with you? I share it with you just to give you a little bit of an insight into what goes on in a pretrial deposition in a medical malpractice case. So let's jump for a moment to Facebook and social media. Are any of your clients on social media? Anybody? Yeah? Okay. The defense sends a notice to me and says, hey, listen, Mr. Oginski, we want 5 years worth of your client's Facebook posts. And I say, what are you talking about? My client, I'm not giving you 5 years worth of Facebook posts. You should know, if you don't already, the defense will scour your client's social media posts forever. They'll go back to the beginning of time to find something that's contradictory to what they have said or what the claims are in this case. In a medical malpractice case, why would a defense firm want to learn information about what's on my client's Facebook or Twitter or Instagram or LinkedIn? Because they're looking for contradictions. They're looking to see if there are any posts about activity levels, what you can and can't do. Maybe you're rock climbing and you claim you can no longer rock climb. Maybe you claim you can no longer ski, and here you are, pictures of you skiing. They want that information. Well, guess what? In years before, in the past, the courts have turned around and said, hey, you know what? Before you, the defense attorney, can ask for this information or gain access to this information, you have to show us that there's some contradiction. You have to show us that there's something there that gives you a hint or a suggestion that there's a contradiction. You can't just willy-nilly send out a request and expect 5 years worth of social media posts to show up on your doorstep. Doesn't work that way. Well, actually now it does, because the law has changed. The defense no longer needs that prerequisite contradictory information or suggestion of it in order to obtain our client's social media posts. But now here's an interesting thing. They turn around and say, hey, give us 5 years worth, or give us 10 years worth. Give us your entire client's account. And we say, you're out of your mind. You're not getting all that. And now it becomes a fight and a negotiation about how much time, what duration my client's social media posts they can get access to. So I'll give you a great example. Last week I was in court in New York County, and this exact issue came up. It was a wrongful death case of a young woman. And we claimed that the improper medical care happened for 3 months before her death. The defense attorney wanted 5 years worth of her social media posts on Facebook. We said, no, that's not happening. So they went ahead and made a motion They said, Judge, we're entitled to this. I said, you might be entitled to some of it. I gave them a couple months' worth. They said, no, we want more. So what happened? So now we go into court. I have opposition papers. The plaintiff, the defense has, listen, we're entitled to get all this stuff. So while we're waiting for the case to be called, I turned to my opponent and I said, listen, what the hell are you doing asking for 5 years' worth? There's nothing in there. And by the way, I already knew that there was nothing in there. So make sure you check your client's social media posts before you're able to say that. So I knew that there was nothing contradictory, but now I'm arguing over the point. And now he says, okay, so give us 2 years' worth. I said, 2 years? What are you talking about? The wrongdoing happened only 3 months before she died. I'll tell you what, I'll give you a year's worth. And you know what? That was fine with him. So now our case finally gets called. The judge, as we're walking up to see the judge, she turns to us, and this is a really interesting point. You think every time you make a motion in court that the judge is so fascinated and interested with what you're asking for. Turns out they're not. And the judiciary in general does not want to get involved in how much of your client's social media posts they really have to, make an order over. So as we're approaching the bench, she says, counselors, do we really need to put this on the record, or can we just step this out? The answer is, Judge, we've already taken care of it, thank you. The point is, in the past, your client's social media posts, they had to have a reason to ask for it. Now, you better make sure there's nothing in there. Oh, and one other thing. Under no circumstances should they be deleting anything. Because if they do that and the defense finds out about it, now you've got a problem. Now you're going to get into a whole bunch of hot water about what was in there, what was contained, and whether it's recoverable.